Yes.
May I please, Lordships?
How's your
Yes,
throat
yes.
now?
Some
Better?
improve. Some improve.
Some
I beg to
improvement.
mention for listing two IM, my lord. One is correction and one is extension of time. Though the matter is disposed of directing the petitioner to appear before the tribunal, he has appeared, but unfortunately, learned bench, my lord, mentioned one voter list. That voter list not available, my lord. And that's why petitioner could not appear in time.
Whether their time is already over?
Yes, my lord. Already over. I have explained in the IM, my lord.
Actually, हो ना hospital से बोलो कोई सर
Friday.
Bless.
May please your lordships the item number 20 lordships. So for adjourn for day lordship I go to hospital lordship. Any date lordship except today lordship.
We'll pass the order and the matter reads. You may leave, no problem.
Lordship.
You ask some of your junior to be here.
Lordship I go to hospital lordship.
Huh?
Develop.
You ask some of your junior to be here. Your colleague, not junior, your colleague to be here. We'll pass the order, but we're not adjourning the matter.
Develop.
Lordship, I beg to mention a matter related to special division bench. Matter, Lordship, pertain to release of the petitioner and bail and suspension of sentence. That may be listed on 15th, Lordship.
Is the appeal admitted?
Appeal admitted and
You'll find this
IA for suspension of sentence and release of the
dependency of the appeal.
Lordship.
What is the offense?
Lordship, offense under section 8 of POCSO and you are sentenced for a period of 20 years.
Friday, 16th.
May I please, your lordship? I beg to, item, WBC number 7145 of 2023, my lord. 7145 of 2023, my lord. Your lordship has heard the matter.
Along with Justice Thakuria.
Yes, my lord.
We'll pass the order.
May I please, your lordship? Lordship, I beg to mention item number 17, lordship. Lordship, MSP Vora could not come due to some health issues, lordship.
Doesn't matter, let the matter reach, we'll pass the order.
Obliged,
Here
lordship.
is not at this stage.
Deeply obliged.
Lordship, I beg to mention item number 26, my lord. The learned counsel for the petitioner, my lord, due to her minor daughter's illness, my lord, he could not come, my lord. 26, my lord. MR Devi, my lord.
Let the matter reach, we'll pass the order.
Lordship.
Your lordship, I beg to mention item number 50 from the daily cause list. The matter may kindly,
Yes.
item number 50, your lordship,
5-3.
1-5.
Yes.
The matter may kindly be entered for the day as seen as medical emergency.
Let the matter reach.
Your lordship.
May I please, my lord, item number 33, my lord. There's a for correction of my lord order. My lord, matter may not be reached, my lord. So my lord, matter may be heard at 2, my lord.
Okay, we'll see. We'll
Ob-
call it up before.
Obliged,
it
my
dies.
lord.
Pick up the motors first where there is no LCS.
Item number 1.
Second half of call for you.
May I please, your lordship? Lordship, in this matter, a brief was misplaced in I should reach chamber, lordship. So matter may be adjourned for a day only for lordship. The next week, immediate lordship. My name is Lord.
I'm on behalf of Aishwarya University.
What's your good name?
RL Sutiyar.
In two last previous occasions, there was no representation.
Also, I have no any idea because
You cannot say you don't have an idea. Since you are appearing before us, you have to own the responsibility.
my name.
Two occasions, no one is represented. We're not concerned who is before us. You may be there, your colleague may be there. There was no representation. 28 to 2020, thereafter, after 3 years, 27/9/2023. Then suddenly you come up and say that brief is not there. And there are names of two council.
My name is not Lordship.
Whoever name is there. Why are you appearing today?
Just I instruction of why.
Don't appear then. If you are making an excuse that your name is not there, we may be very strict. Your name is not there. Don't appear.
Lordship.
Don't give those excuses. My name is not there. We are not on the names. We want representation. If you are instructed by your friend, your colleague, it is okay.
Lordship.
On 19, the matter is pending.
Yes.
Will you able to tell us what is the status of this case? There is no final order.
Yes. Okay, I will get the instruction, but
List on. 19. Enabling Mr. J. Pine, Standing Council Home Department. This was finally disposed of or against the order at 15/5?
this is my lord. There is,
Prayer is only with regard to 15/5.
yes, 15/5/2019.
But it has been disposed of by 8/1/26. That is not under challenge. That is not under challenge. Page number 9. No, it's covered. That was the first time. When she was declared to be an Indian citizen. Please, Indian citizen. List on 19th, enabling Mr. J. Pine, Standing Council Group Department. We apprised the court about the status of
23rd.
case number F.T.Udin Nolbury, NAM and capital. That's two. Case number 86/2015. Pending before NS number, tribunal number 2, Nolbury. Get us the status.
My lord, instead of 19, can it be on 22nd or 23rd? I may not, both of us will not be available on 19. So
22nd.
22nd. Right.
9. 9.
Right. Right.
Mr. Sharma, we wanted to know about the status because it was returned back to the tribunal.
Yes, Lord, instruction is given. I have given the instruction.
Yes.
যিমান কৰাৰ পিছত absent আছে এইটো step. Orderটো কেতিয়া পাছ কৰিছিল? High Court order was passed on 1/3/2021. And after that, 21. After that, record was placed before the tribunal lordship. And petitioner was continuously remain absent.
We'll take it after some time or at 2. Try to locate the counsel for the petition.
Yes, Lord. How long is it?
May I please, Lordship? My lord,
Let the matter be called first.
Nine Madhya.
there is an expiry order. Page 39. My lord, actually, I have not a good case so far expiry order is concerned, because I appeared and thereafter I
Mr. Sharma, you
disappeared.
have the record.
Yes, Lordship.
This is the record.
Yes.
Thereafter I did not appear, and as a result of which the learned tribunal passed the expiry order declaring me as the
Mr. Mahmood,
my lord.
you go to the records along with Mr. Sharma and make your submission at the.
At 2.
Since the records are there, for the interest of justice, have a glance of the records
Yes.
along in the presence of Mr. Sharma.
But I have said, my lord, I have not so good case, but expiry order, I have so many documents to prove my citizenship, including voter list of 1965 of my father. So otherwise, my lord, I have a case of citizenship. But I have committed some mistake. So lordship, there is some judgments of the Honorable High Court also that when the parties have documents and those are sufficient to prove his nationality, but due to some reasons he remained absent for certain dates, High Court should give a chance, provided some cost may be also awarded. So because citizenship was valuable right, and there was no order of warrant of arrest. Even tribunal has also the power to issue warrant of arrest. That was not done. In a shortcut manner, when I did not appear, I was declared as foreigner. So my lord, my submission is I have not, initially I have not a better case, but a case for consideration.
So, my lord, the order
Why
may be,
didn't you appear?
my lord,
Why didn't you appear?
my lord, actually, I was told that if necessity arises, then we will apply, will apprise you. That was his version. That my lawyer told like this. But I have not mentioned this because many times parties do not.
Just a minute.
Yes, 39. Otherwise, I have some judgment also in my favor.
What does it say?
Yes, my lord, that is. That is 2022, 1 GLT 756, para 7 and 9.
2022 1 GLT.
756, para 7 and 9.
Name?
Name of the party Rajendra Das and others. Here, my lord, the Honorable High Court was saying that declaration of as foreigner post 2/3/1971 stream ex parte proceeding against proceeding held. Tribunal proceeding have huge ramifications for any person's citizenship, a valuable right which needs careful examination before being deprived in respect of any proceeding. Proceedings possessing documents which are indicative of Indian citizenship. Tribunal ordinarily meant to give its finding after going on merits of a case, not by way of default of a party. Then, my lord, in Foreigners Tribunal's Amendment Order 2013, it is said they go through the Foreigners Tribunal's Amendment Order for issuance of warrant. If proceeding does not appear or disappears, there is no provision that due to non-appearance, a person can be declared as foreigner.
Mr. Mahmood, can you tell us why the provision of Order 3 has been included in 1964? Can you tell us Order 3A, Sub-Order 1 in the 1964 order?
No,
What is the reason?
but in 2013, there
No,
was some
just tell
amendment.
us whether it has been amended, whether the Order 3A1 has been amended.
No, that is not amended.
Then what is 3A1? Kindly read.
Some addition.
Kindly read 3A1.
I have not brought the Foreigners Act today.
Mr. Sharma,
But,
if you have it, kindly give it to me.
no, I understand, my lord, I have initially I have to.
So it is a fact.
3A,
1.
yes, 3(1), the tribunal shall serve.
The entire provisions of 3A.
3A, where the Foreigners Tribunal has passed an executive order.
No, read
Head
the
note,
title, read the
title of the 3A.
procedure.
Procedure for setting aside executive order.
So tribunal has the power.
Yes.
In that case, what is the procedure to be followed by a proceeding?
Yes, that within 30 days it should
Then-
apply.
Where is the illegality in disorder?
No, I am not saying that, but I am not saying there
So
is
if some
illegality.
judgment has been passed not in conformity with the law, we cannot do anything.
No,
We are here in circle.
I have also read the judgment. This is also judgment of our High Court.
Maybe.
And there is a settled position of law if the
Let us see.
coordinate bench, let me submit, my lord.
When
Then
the-
I will submit on
When
merit.
this particular provision has not been
Then
considered.
I will submit on merit, my lord.
See,
If the coordinate bench does not agree with another coordinate bench, matter should be referred to larger bench.
What was the ratio laid down in the earlier case? regarding
I
the
understand, man. I understand that I have appeared, but thereafter decided it is my fault.
No. What was
I
the-
admit that.
Mr. Mahmood,
listen to my brother.
It's a different question. What was the ratio laid down regarding issuance of warrant of arrest? Is there a ratio laid down?
Ratio means, my lord, that is ratio
You are depending.
is only that
No.
a person sometimes do not appear. The ratio is this, my lord. For non-appearance, a court should not ordinarily declare a person.
Where is the ratio? Which part of the judgment?
No, it is clearly stated
Where?
that now expert order.
Regarding expert order,
Yes, so here, tribunals, amendment order 4E of 2013 for issuance of warrant, if proceeding does not appear or disappears.
Where it has been stated that a proceeding can never go ex parte.
No, no, I am not saying
Unless warrant of
that.
arrest.
I am
is
not
issued.
saying that, man.
So that is it. This provision has been inserted along with 3A. This is also.
Yes, yes, the
this is
combined
also-
reading should be there.
So 3A is also being introduced by the 13th amendment.
No, my lord, actually, my lord, I admit, my lord, there was lessons on the part of the
Okay.
proceeding. So my only limited submission was that lordship may kindly interfere the order, I may be given a chance,
We'll consider-
and I shall, some cost may be also awarded, my
we'll
lord.
consider.
That is my. Yes.
Let us not Friday. We'll go by the record of.
Yes.
Lordship. Give us the record.
Can it be on 22nd?
Mahmood, we are.
Can it be on
reiterating,
22nd,
If there is
Lordship?
anything in the.
Can it be on
coordinate bench
22nd?
Yes.
Regarding warrant
Yes,
and vis-a-vis an expert
Yes.
proceeding, please.
yes,
indicate
yes, definitely, I shall try, but I initially said I have not a good case.
22nd.
Lordship, or after 19th, Lordship.
Thursday,
Fine, and-
Thursday,
Thursday, I can.
this Thursday, 15th,
Yes, yes.
15th, Thursday.
The thing is, this my lord, police is behind me, that is,
Thursdays.
yes.
This Thursday. Today is Monday, we'll have it on Thursday.
Obliged, man.
Pardon, Mr. M. Mahmood, Council Affair, M. E. Mahmood, Council for the petitioner. And Mr. Z. Sharma, Standing Council, Home Department, Assam. Also heard Mr. From for the respondents, for the KIL Varadiva, PN, E. Sharma, President. Pursuant to the order dated 22/01/2024. Mr. Sharma, Standing Council, Home Department, have placed the relevant record of application number 21/Baksa/2023. List on 15. Mrs. Ayo.
10.
May I please the lordship? Lordship. The instant writ petition.
There is no provision for appeal.
My lordship.
After this Union of Indian Purushottam Das case, Lordship, the jurisdiction now has been extended up to, but Lordship is not applying appellate jurisdiction.
Obviously, that is what the writ petition.
Lordship, let us file our objection thereafter only. We have a strong objection to the grant of bail. It's only bail has been refused at this stage. The matter is pending before the tribunal. And the allegation is also serious, Lordship.
4 years.
And that has been proved in the court martial proceeding. And Lordship is aware of the limited jurisdiction which Lordship will exercise in interference with the court martial proceeding. Let us file our objection, thereafter lordship will consider.
The Armed Forces Tribunal is still considering the
Yes,
matter.
and appeal is pending before them. His petition is pending before. Only the bail has been refused. We are yet to file response before the tribunal also.
Refusal of bail can be questioned in a writ proceeding.
That's lordship.
My lord, in the particular judgment which I have referred, my lordship, which is online, it was passed in the year 2023, my lordship. The Honorable Apex Court has held that any order from the tribunal, my lordship, can be challenged before the read jurisdiction, my lordship. In a limited scope is there, if any fundamental rights and other thing is
This
violated.
is an order of refusal of bail.
Yes, my lordship. My lordship, but my bail, my lordship, no ground has been given, nothing has been given.
No, will a writ lie?
Yes, my lord. My lord, as per Supreme Court judgment, my lord, this
Which
judgment,
paragraph?
my lordship. Earlier it was as per,
What is the stage of the appeal?
my lord, it has been filed, it has been admitted, my lordship. But
Admitted when, which day?
my lordship, it was admitted on 9/10/2023, my lordship.
9/10.
Yes, my lordship.
In
On-
Guwahati.
Yes, my lordship.
Normally, Mr. Chakraborty, how long does it take
Lordship.
for, normally, we are not, in a given case, it may take more time, it may
Lordship.
take less time.
I'm just finding out if there is any provision to dispose of within such time limits or.
No, we are not in the provision. Normally, how much, you may be aware of the proceedings.
Now it started pouring in. The AFT cases are now against the order of the AFT just started after this judgment. So few cases have come up.
No,
This
not
is one
here,
of the case.
not here. Appeal before the, proceeding before the tribunal. How long does it take normally?
Within a year, it's finished.
Within
up.
a year.
Yeah, lordship.
Which paragraph?
My lordship. My lordship, page 25, in the Union of India, in civil appeal number, title, Union and short reference to larger bench.
Page 25.
25.
Please. Page or paragraph?
Sir, page, my lordship.
Page.
No, my lordship.
Paragraph?
Page, paragraph, my lordship, is the
Three,
demand.
1-3.
Yes, my lord.
Yes.
As petitions filed under 226 and the constitution on of the constitution against orders of the Armed Forces Tribunal are held to be maintainable. This matter would also require to be remanded to the High Court to be decided on merit, since it is a service matter personal to the litigant and does not involve a point of view.
What is the context? 226 jurisdiction is not barred. L. Chandra Kumar has made it very clear. It will come before revision bench against orders of tribunal, but this is an order of rejection of a bail application.
My lord, rejection of a bail application also comes under the purview of order, my lordship.
No, can we have exercise the powers of judicial review?
My lord, ultimately, it's a discretionary power, my lordship. If the Honorable High Court thereafter is on its discretion, my lordship, is to interfere, my lordship.
I don't think you have correctly applied the law. Our jurisdiction is not barred. We have the jurisdiction, but to do what? Not for examining the correctness passed in a bail petition. We have other avenues.
My lord, at least my bail petition, my lordship, in the rejection, my lordship, there is no reason has been stated as to what was
Those are different matters.
appropriately it has been rejected. It is in unreasonable order, my lordship.
Reply.
The bail application also, my lordship, I have contended several, I have taken several plea myself, my lordship. And the bail
We
application,
are on the maintainability, Mr.
Yes,
Bhaskar.
yes.
We are not on the merits. No, bail has been cancelled.
Because
rejected by
Lordship,
a-
15 forces, it can be interpreted only if there is a material irregularity when the legally not sustainable and grounds have been, and on is wrong question of law. That are only the 3 grounds available.
That too in a regular repetition.
Regular.
After a final order is passed. Here is an order of rejection of bail. A bail has been rejected by an appropriate court. Can you come before this court in a writ proceeding?
My lordship, in this judgment, my lordship, honorable.
No, just answer.
Yes,
Bail, normal bail,
Yes,
rejected.
My
In a
lord-
murder case, rejected.
lord-
Can you come to writ court?
My lord, in case of NIA case, it is, yeah.
And I give the power to the High Court, statute
ma'am.
itself.
Yes, my lord.
Don't recite some other.
Yes, my lord.
It's a statutory provision.
Provision. In this,
Show us in the FT.
no, no, my
uh,
lord.
This particular act that High Court has been in jurisdiction. Or even for deciding application for bail. I think we have serious doubts in your approach regarding the forum.
My lordship, at this stage, my lordship, short date may be fixed at this stage. I'll satisfy your lordship, my lordship.
And otherwise, these are all introductory kind of orders. Why should we interfere? What is your age?
My lordship, my age is 20.
How many years did you?
30 years.
30 years. How many years did you serve?
My lordship, I have served.
He entered into service 2013.
10 years. 10 years.
10 years.
When was this proceeding initiated?
My lord, it was initiated by
Manipur, Lordship.
Where? Sorry, when?
2021, my lordship. It was initiated. Yes, my lord.
It's around 13 to 21 years. 9, 8, 7, 8 years you have served. Mr. Chakraborty?
That's correctly held, Lordship. This only interpreted at this stage, Lordship. To interpret, the whole matter is still before the tribunal. And the allegation has been serious and it has been proved, finding is been with reasons, Lordship. It's not that it is without any reasons. The reasons, Lordship will find it, finding will find page 394 onwards, Lordship.
Heard. Mr. S. B. Loskul, learned counsel for the petitioner. And Mr. B. Chakraborty, learned CGC. For the for all the respondents, number 1, 2, 3. This petition has been filed by the petitioner, challenging the order dated 16. Order dated 09/10/2023. Passed by the Armed Forces Tribunal, Regional Branch, Guwahati, in MA number 36/2023. Arising out of original application to indicate appeal 24/2020. Appeal OA, original application to indicate 24/2023. Whereby the tribunal rejected the bail of the petition. It is placed before the court by Mr. Chakraborty. That is submitted that the concern wave referred by the petitioner when OA would indicate a number 24/2023 is still pending before the tribunal.
for adjudication. Issue notice. 2 weeks.
3 weeks, Lordship, because we have to send that vetting also for objection. Lordship. Because this will come from Manipur, Lordship.
I don't know how far. 2 weeks. As Mr. Chakraborty, Planet says they accept notice, but no problem notice at release. The respondent shall file their affidavit as to security, if any. Honor before the returnable. Petitioner shall serve requisite extra copies of this within the annexes to Mr. Chakraborty by tomorrow, of any necessary acknowledgement copy in writing. Maintainability of this writ petition is kept open and shall be considered at the time of its admission stage. At the time of which admission.
Oblige your lord. Highly obliged, my lordship.
Yes. So let's be honest, sir.
Please take your seat.
When he was taken into custody?
My lord, I do not have file. File has been taken back by the petitioner, my lord, because trial is going on, my lord. And my lord, what happened, my lord? Impugned order was set aside, but order was passed in the IA, my lord. It ought to have been passed in the main writ petition, my lord. That is why, my lord. Otherwise, my
IA, what order passed?
impugned order was set aside, my lord. But that order was ought to have been passed in the WTC, my lord. Petitioner was in custody for more than 3 years, my lord. Thereafter, he was released from my lord.
Mr. Sharma, I think the entire expedition has got to be disposed of. You
Yes,
see
Lordship.
the order 1/3/2021.
Yes, Lordship, I have civil.
IS 407/2021
Yes, Lordship.
and this has been done by an elaborate order after perusal of the
Yes,
record.
yes, my lord.
Yes, Lordship.
I think the petitioner has rightly not appearing.
Lordship.
And he's appearing before. the-
Yes, my lord.
He is appearing, Lordship, and Lordship, my instruction is that earlier warrant, due to non-appearance, Lordship, warrant of arrest was issued, Lordship. Next date was fixed on 19/2/24.
That is a different matter, but
Yes.
this restriction has gone only because this order has not been reflected in the petition.
Yes,
It has
sir.
been again listed for this.
Yes, my lord.
And also spelling. At the outset, Research and Council for the petitioner submits that the records have been taken back by the client. He further submits that in fact, the writ petition itself has been disposed of by an order that is 1/3/2021, which however is in the records of IA Civil 407 of 2021, which was also disposed of along with the state writ petition. We have perused the aforesaid order dated 1/3/2021, and which full stop. The said order clearly reflects that it is a final order by which the impugned opinion dated 25/9/2019 passed by the learned FT Jorhat in FT case number so and so was set aside and the petitioner was directed to appear before the tribunal. Full stop. We are also of the view that since the order has been put in the records of the IA Civil 407 of 2021, perhaps it is for this reason that this writ petition has again been listed, which otherwise has been disposed of along with the IA. Full stop. Para? Para? At this stage, Sri G. Sharma, learned telling council Home Department has placed on record a written communication received by him dated 1/2/2024 from the learned tribunal. Full stop. Para. On perusal of the same and on consideration of the facts and circumstances, we are of the opinion that no further orders are required to be passed in the writ petition, and the same accordingly stands closed in terms of the order dated 1/3/2021. Full stop. The learned tribunal would accordingly act would act in accordance with law and dispose of the proceeding expeditiously.
Obliged.
As provided in the Foreigners Act 1946 in the order 1964.
May I please, Lordship? Okay, impugn order, page number 36, Lordship.
Where is the link document?
Lordship, Exhibit D1, relief eligibility certificate issued in the name of the father of Sunadon Das, Lordship. Page, Lordship, 17.
That is in the name of father. How you approve your link with your father?
Lordship, school certificate, school living certificate, page 22, Lordship.
22. Has it been proved by the
No, Lordship.
so
Lordship, voter list of 2005, Lordship, petitioner name appeared along with father, Lordship. Along with
Page?
father, page 24, Lordship, at serial number 907.
not a certified copy?
Lordship.
So whether the exhibit D3, page 24, 25, and except 4 was proved.
No, Lordship. No documents were.
Mr. Sharma? Yes, sir. Section 9 of the Foreigners Act.
Yes, Lord Chief. Pardon of proof, Lord.
School certificate not approved.
Yes, Lord Chief.
Then the Gaon Panchayat Secretary's document was not proved,
Not
certificate was not proved. Voter list was not certified.
Yes.
How will you get the benefit?
No, Lord Chief.
How will you get the benefit? Tell us. What is the ground for challenging this order?
Page 8, paragraph 7, Lordship.
This certificate at page 22 is of which school?
Yes. Okay. Lordship, name of the school, 200 number, Adaligul LP School, Lordship.
So this was an LP school.
Yes, Lordship.
It is given by whom? Who has issued this certificate?
In below signature of the head of the institution, Lordship.
Who's the head? A teacher or DI?
That part, Lordship.
There is a standard format of this kind of certificate. No, till now we have seen many certificates. It comes under the pad of the school
Yes, sir.
or the institution. Here, for the first time, we are
Yes, Lordship.
to come across a certificate.
Mm.
Which where the school name is not there, it is written by hand.
Yes, Lordship.
And you, this is up to class for the LP school.
Yes, Lordship.
Your date of birth is 1986, February,
Yes.
correct?
Yes.
You came out of the school in 1997
Yes.
in class 5.
Hmm.
Study classes 1 to 5. You have seen down in the column. In the 1, 2, 3, 4, 5th column or 4th column. Thereafter, what happened? From 97, did you go to any school after class 5?
That part I have no knowledge.
No, you must have stated something.
Yes, Lord.
You are not no longer means the petitioner has no knowledge. It
Yes,
cannot be.
sir.
You have to ask the petitioner, what did you do after 97? Got married, left school, did not study, what have you stated?
Yes, sir.
Nothing. It was set up 1, 12, 20, 22. The foreigner style learning. The foreigner style. Well, yes, when was this issued, which date?
Your Lordship,
Date of issue of the certificate?
school certificate.
Yes.
24/7/80.
No, that is the memo.
Your Lordship.
85, it cannot be.
Yes.
Yes,
If
Lordship.
you are in school till 1997, how can it be issued in
Yes, sir.
85? You are not even born in 85,
Yes,
unfortunately or fortunately. You were born in 86.
yes, sir.
No date.
Yes.
This voter list at page 23, 24 are not certified copies. Not certified copies. Not one. Not true. Any voters list of your father, Sunadhar? Sunadhar,
Only 2000.
any voters list?
Maybe they are but not produced before us, Lordship.
Maybe they will not do.
So further chance, Lordship, to produce any voter list, Lordship.
Further chance. Proceeding was of the year which one? 2018. The imperial opinion is of the year 2023. 19, 20, 21, 22, 23. 5 years. You got chance. If you were unfairly dealt with or the ruling was discriminatory, then matter would have been different. We find that you have been given adequate opportunity. I think it was
Mr. Pai and Mr. Sharma, earlier, please come to paragraph 7, which the petitioner said has read the ground. This is that the school certificate. Yes, Lordship. Establish linkage with the further agreed beyond. Yes, and it's certificate with no replace not for. Yes, Lordship.
Now, issue is, that document not required to be proved
Lordship.
according to the petition in terms of the judgment of the, say, judgment of the apex court. Regarding this, there is an observation made by Justice Manojit Meena and Justice Dekar, to my knowledge. Because document may be placed in agreement.
Yeah.
But the contents of the document has to be proved by the person who has
Yes.
issued the same.
Yes.
There is a specific observation considering this particular judgment of the apex court. The apex judgment which is. Mr. Pai might remember because
Yes.
this judgment was cited in earlier cases. That this kind of school certificates. Presumption. Under the evidence act. But there the observation of the court was, document may be there, but the contents of the document have to be proved. And if it is a public document, how it is to be placed, both the things were decided by this court earlier. Above that, what we have noticed that there was no such date when this certificate was issued.
Yes, Lordship.
That the order of the Deputy Inspector of Schools of 1985.
Yes, Lordship.
That is with regard to the power issued by the DI by that communications.
Yes.
So the headmasters of the schools for issuance of such transfer certificate or such certificate. Nothing else.
Yes. No. And apart from then, my humble submission is that Lordship, section 90 of the Evidence Act is only discretionary in nature, Lordship. So it is not mandatory provision.
Section
90 of the Evidence Act. I don't. So there is a line quoted, Lordship, court may presume, Lordship. So, yeah.
presumption documents.
Where any document purporting or proof.
So this first it is a presumption.
Yes.
There are preconditions. It has to be a document for 30 years.
Yes.
This school certificate does not bear a date.
Yes, Lordship.
So that will not come in.
That will. Regarding relief eligibility certificate, Lordship. They have
No,
taken
that
the.
has to be a linkage between the petitioner and her projected father.
Yes, yes.
Without that, that linkage document will not come, that relief document will not come.
Yes, Lordship.
And if you read section 30, there has to be a specific pleading that this certificate was issued by so and so.
Yes.
Where is the disclosure? What was the name of the headmaster?
No, nothing.
Who
Lordship.
was issued? When was it issued?
Nothing,
Nothing.
nothing. Lordship.
These are given only to give benefit in a bona fide case.
Yes,
Where
Lordship.
a
Yes,
full document
Lordship.
is produced, but the
Absolutely.
person who has authored the document or signed the document could not be produced.
Yes, Lordship.
Then the person who says that yes, it was my headmaster, his
Yeah.
name was so and so.
Yes, Lordship. But there is
Or-
nothing, Lordship.
But she is not, we cannot trace him out. Then a presumption, that discretion which you rightly said, a discretion is vested on the court to
Take this.
to presume
Yes,
the veracity of such document.
yes, Lordship. But here is nothing, Lordship.
Anything else you want to submit?
Lordship, page 9, Lordship, paragraph 9, Lordship.
Yes.
Lordship, 2HA Lordship, persons belonging to minority communities in Bangladesh and Pakistan, namely Hindus, Sikhs, Buddhists, Jains, Paris, and Christians, who were compelled to seek shelter in India due to religious persecution or fear of religious persecution and enter into India on or before the 31st December 2014, Lordship.
What do you have to say, Mr. Sharma?
Lordship, rule is not yet framed, Lordship. Notification. Notification. 2016.
Lordship, Annexure 8, Lordship, page 44.
2015.
Case 44.
Lotion. Religious person. WC person.
Madam, who is the proceeding? Is the father proceeding,
No,
so-called
Lordship.
father, or
Daughter, Lordship.
one
Yes.
so-called daughter?
Yes, Lordship.
This should be applicable so far as the father is concerned.
Yes.
Per se, and if you can make out a linkage between you and your father,
Yes, sir.
then you would be covered by this rule. There is no dispute with these rules, existence or application.
Hmm.
But you have to establish a linkage which is reasonable, cogent, reliable and acceptable. You have introduced two documents. One is a school certificate without a date. The author is not produced, was not produced, contents not proved. And the certificate itself looks to be doubtful. We have not seen such a certificate. Leave aside the certificate, voters list of 2005, along with your so-called father, Sonadhan. It is not a certificate copy.
The further test, I will produce Lordship certified copy.
After 5 years, if you become wise, we may not allow you to become wise after 5 years. 5 years is a pretty long enough time. Is number 31. That's 17.
Number 27. Exit D4 in the judgment itself. D4 has been left out because it was not been approved. Go to the, they did not certificate for it, not hearing nothing. Original nothing. But not an extra for on the exhibitors. You can put which exhibit. But you can make it. Page 38. The list of the
Mr. Sharma. Why D4, there is no mention about D4 in the judgment? Exhibit D4,
Page 39.
come to 38 also.
Sorry, 38, not 38.
We are not in the admissibility part, authenticity part.
Yes,
There is not even a
no, then
mention, why?
regards to changing. Yes, D4 is not mentioned here, Lord.
But specifically mention exhibited D1 to D7.
Yes, Lord. D4 to PDC, evidence to China.
Madam, why D4 is not mentioned? There may be something which we know, we do not know.
D4.
In her written statement, she annexed lordship voter list of.
That we have seen, see, and written statement as well as your affidavit evidence. Why is it not mentioned? What was wrong?
Tribunal opinion lordship.
See, please come to page number 17.
17.
Seventeen, 18, its series not there, but anyway. What we could see at page number 22, down below left side. It is exhibit D2,
Yes,
down here, right? Then come to page number 25.
Mm.
Down below exhibit D3. What about this page 24? Whether it was exhibited,
Tribunal mentioned one.
whether it was exhibited.
May I please, Lordship? Lordship, regarding D4, Lordship, perhaps it was not a certified copy, that's why it was not
Question
reflected.
of,
Otherwise,
not on that.
yes, Lordship.
The exhibit 1 and this particular voter list should have been exhibited by the petitioner then, but the thing is this in the order, there is no mention about D4, but it is written that D1 to D7.
Yes,
There has to be some mention about D4 also.
yes, yes. Otherwise, before is a 2005 voter list, as per.
Whether it is certified copy or what copy, whether it has been placed. There is no mention.
Yes.
Page 34, Lordship, Exhibit D4.
Page 34. What do you want to show?
The Exhibit D4, no, I think. 32, Lordship.
34 years, we are at 34.
32, Lordship. This is
32.
voter list, Exhibit 4, Lordship.
That is the reason I'm asking you. This particular voter list which you have exhibited.
It is what you have said.
Which voter list, 2013 or 2005?
Five, Lord.
Five. Because in that particular paragraph, you have mentioned about 2013 also.
13, along with his husband, along with her husband, Lordship.
13 with husband, Kalidas.
Kalidas.
5 with father, Sonada.
Along with
That is why in the paragraph you did not mention the said voter list.
this Lordship.
You did not say it is those voter lists.
And
Which voter list, 2013 or 2005?
I don't have it. No, I don't have it.
Here you have an X copy which has not been exhibited. So 2013 voter list also you have not exhibited, not been annexed here. That is why I wanted to know from you. Which voter you have exhibited, was it 2005 or 2013?
As per written statement, I had annexed Lordship 2005 Lordship.
Cannot be said because reading those two paragraphs, whether in the written statement or your evidence in affidavit, it is not clear. You have to prove that document, right?
Yes,
Which document you have placed before the tribunal? That was an annexer.
It was sometime during riot near about 2015 years ago. With relation by
Lordship, that part record may be called for Lordship.
Yeah, in the middle.
Also, and in the meantime, some protection given to her Lordship.
Notice.
Mr. Sharma, please compare page 27.
Yes, sir.
The pleadings in the written statement and paragraph 6. First, you come to page 27. Please read paragraph 6, the pleadings.
That the OP is a genuine Indian citizen. She has exercised her franchise in several elections before her marriage in the voter list of 2005. Her name was enlisted along with her father, mother, brother, and sister under LA 05 Badarpur constituency under part number 103, serial number 90770.
The only voter list which you have mentioned in the pleadings is 2005, along with her parents, father, mother and siblings.
Yes,
Okay?
Lordship.
There is, thereafter, the pleading regarding the marriage with Kalidas has come in paragraph 7.
Yes,
And in paragraph 8, she mentions about her voting after her marriage in
Yes, that's it.
2013.
yes,
So there were mentions about two voters list, one of 2005 and one of 2013.
13, yes, Lord.
And the annexures were annexures 3 and annexure 5.
Yes,
So if we come to the corresponding affidavit at page 31, the
Yes.
depositions in the chief,
yes,
paragraph 7. Okay, please read.
that I am a genuine Indian citizen. I have exercised my franchisee in several elections before my marriage. In the voter list of 2005, my name was enlisted along with my father, mother, brother, and sister under Badalpur constituency under part number so and so.
Till this part, it is the replica of paragraph 6
Yes, yes,
of the written statement. Now this paragraph continues.
yes,
Kindly turn over to the next page. Same paragraph.
yes, Lordship. In the voter list of 2013, my name was enlisted along with my husband, Sri Kalidas, under LA 12 Audharbon constituency. In this connection, Election Commission of India issued me a voter ID card at number so and so.
Now read the next line. The same,
We said voter list.
which one? 2013,
No.
not 2005.
Yes, Lordship.
And the voter ID card are enclosed at D4 and D5.
Yes,
2005 has not even been brought to records.
yes, Lordship.
Either uncertified, certified, nothing.
Yes,
If you, from the other cases, you will see the voter ID cards, right? EPIC
yes,
were issued only in the year 2013,
yes, Lordship.
not prior to that.
Yes, Lordship.
So
Lordship, again, Lordship will kindly see page 35, Lordship. Cross part, Lordship. It was taken on 1/12/2022, Lordship. So, Lordship, I am the opposite party of the case. I am at present 36 years old. I do not remember the exact date of my birth. I do not remember the exact date when my parents entered into India from Bangladesh, but it was sometime during the riot near about 25 to 26 years ago. Lordship, that means, Lordship, if we accept this statement, Lordship, then whole thing good.
No, there may be, then read further. She may not remember when was it, 25, 26. I was born in,
I was born in Rakesh Nagar, Kalimganj, and went to Iragul LP school. I studied till class 5 in that school. I casted vote since 2005. Initially from my parents' home and then from my matrimonial home. I am a housewife. I am not a income tax return payee. It is not a fact that I have deposed falsely. It is not a fact that I have illegally entered into India from Bangladesh. Lordship. So, Lordship, from that deposition was taken on 1/12/2022. So, in her cross, Lordship, she stated that my parents entered into India from Bangladesh, but it was sometime during the riot near about 25 to 26 years ago, Lordship. So, Lordship, as per her deposition, she entered India. Her parents entered India during the year 96 or something like that, Lordship.
How many witnesses were there?
One lordship. Petitioner herself.
Your father was alive or not?
No lordship.
Mother?
Mother. No. No more lordship.
Where have you stated? In your WS?
Page 2, paragraph 2, lordship, late Sunadhan Das and her mother, late
Paragraph,
2, lordship,
page,
page 4, lordship,
no, in the written statement.
or written statements. Mhm.
They were not stated.
Yeah.
You are? Yes,
P. Ghosh, lordship.
for the petition. Makiliki. V. Sharma, P. Sharma. Dated 18/05/2023. As well and member for an tribunal second session in FT second case number 1576 of 2002. Declaring the petitioner to be a foreigner with the Foreign Act 1946. Illegally entered into illegal migrant. Illegally entered into territory of India. From the specified territory of Bangladesh, ignore after 25 period. Call for the records. We propose to. Peruse the original records of such and such offense. The proportionate party, the institutional records and call for the records of such and such. And list this matter for motion immediately on receipt of the concerned records from the state foreign estate. List of them.
In this case, lordship, the petitioner filed his written statement, lordship, along with all the photocopies of the documents, lordship. 14 documents he included in his written statement, lordship. But later on, lordship, no evidence in chief was filed, so he was declared as a foreigner, lordship. And before that, lordship, earlier this petitioner was declared as a foreigner ex parte, lordship. So he approached this honorable high court and this court granted him permission to appear before the learned tribunal filing written statement. That order, Lordship, I has enclosed as Annexure 1, page 12, Lordship. In fact, Lordship, there is no illegality in the order, Lordship, as because the petitioner filed his written statement along with all the photocopies, Lordship. He applied for the certified copy of a voter list of 1971 in the year, in the month of January 2023, Lordship. So that while waiting for the voter list of 1971, Lordship, he could not file his affidavit evidence here. The Lordship will find the earlier order of this court, page 12, Lordship, and 13. In para 7, he was directed to appear before the learned tribunal on 25/2/2021. And accordingly, he appeared and filed his written statement, that is page 14, Lordship, type copy. Along with his written statement, Lordship, with 14 documents he enclosed, Lordship, the NRC of 1951, 1965 voter list showing the parents' name, Lordship, and 1970, and Lordship, voter list of 1989, 1997, Gaobura certificate, voter list of 2005, 2010, 2014, and 2019. Registered sale deed showing that the opposite party has landed property at village W, Lordship. All the documents were, Lordship, in photocopy. And originals are lying with the hands of the advocate, Lordship. Only, Lordship, in the month of January 2023, he applied for a voter list, Lordship, that is on Annexure 9, page 36.
Madam, the High Court's order is of February 2021.
Yes, Lordship.
What have you explained that you have applied for the document in January 2023 after 2 years?
Lordship, that is written statement, Lordship, as per High Court orders, written statement
You have
was filed.
applied for the document after 2 years.
Lordship, all the other documents are included along with the written statement. Then the
And why
engaged.
you applying for a document after 2 years if you say, if you feel that the other documents are good enough to protect your interest?
Lordship will
And
find
for
that.
one document which you apply after 2 years of the High Court's order, and you find fault with the,
No, Lordship, kindly see the Annexure 4, page 26.
yes.
His father's name appeared as Hamed Ali, son of Jori Sheikh, and mother name, Lordship, Tafiran Nessa, wife of Hamed. And in 1970, Lordship, his father's name appeared as Hamed Ali, son of Jori Sheikh, but his mother's name appeared as Abiran, Lordship. Then the engaged counsel advised him that you show the correct name of your mother subsequently appeared in the voter list. So 1971, Lordship.
But how will you? Please come to parents, page 13.
13, Lordship.
The order of the.
Yes, Lordship.
Read para 6.
The petitioner will approach before the Foreigners Tribunal at Nagaon within a period of 15 days from today and will file his written statement and adduce evidence in support of his claim.
So
So he filed written statement, Lordship.
uses evidence within
Evidence-
15 days.
Lordship, all the
Did
originals
not say
were,
thereafter.
Lordship.
When did you adduce evidence?
Evidence was not adduced, Lordship. That is the case, Lordship. Only I am praying before your Lordship to give a chance to adduce the evidences, Lordship.
You
And-
said you had all the documents except one copy.
Yes,
Let
Lordship.
us assume.
It
let
was
us
not
give-
a-
Let us
Lord-
give full benefit or we accept what you say. What
Lordship.
prevented you for adducing the evidence with the documents which were available with you?
Lordship, that is the case. The petitioner is saying that I have handed over all the originals to my engaged counsel. And Lordship, we cannot blame my colleague, Lordship.
You have
He is
already
also,
come to the High Court once. You know
Lordship.
what is the proceeding.
I know, Lordship, it's a very,
It was remanded back with a particular time to file your written statement and your
Lordship.
evidence. And that was after in the year 2021.
yes, Lord,
February
normally,
twenty
Lordship.
twenty-one. This opinion is rendered when? In 2023.
Lordship, normally in trial courts, Lordship, written statement was filed earlier and then evidence were filed, Lordship. But here maybe they were not understand, they have not
We had 2
understood, the-
years.
Lordship.
We are not in 15 days or 30 days. We've got
Some
30
of the
or-
dates, Lordship, the
we have
entire
almost got
records,
24 months. 2
Lordship,
years.
the entire record is not before me, Lordship, so I could not say whether on what dates what happened, Lordship. Only the impugn order says, Lordship, the written statement was considered by the learned tribunal. Page 42, Lordship, the written statement along with all the photocopies was discussed by the learned tribunal, Lordship. Second paragraph, your Lordship, hence there is no other alternative for the present member other than to pass an order opinion on the basis of proceedings written statement, Lordship. In his written statement, the proceeding stated that his parents' names were late Hamed Ali and late Tafiran Nessa. His grandparents' names were late Jari Sheikh and late Mirjan. The proceedings parents and grandparents were permanent resident of village Kakotigaon, Mauja, Jarabari, PS Kampur district, Nagaon, Assam. And they have landed property as well as residential house at the aforesaid addresses. The proceedings father name appeared in the NRC of 1951. Lord.
R. Chaudhary, Emerson, what is the issue? They find. The next one. Two. Four. P. Sharma, ID 771, three. You want to get information?
Yes.
We will only. On the behalf of Mr. A. Sending for the. This one number 5. By the improved opinion. Improved or restless opinion. There are 30/11/2023. The member fairness tribunal 9 Nagaon in FT case number 60 of the 2016. By order declared the petitioner order declared the petitioner to be a foreigner under the Foreigners Act 1946, who had illegally entered the territory of India from without any valid documents from the specific territory of Bangladesh on or after 25 1971. Dissatisfied? This is petition of Congress. Like the previous one. We propose to. There was the records of the FT case number 60 of the 2016 declared disposed of 30/11 by the Fairness Tribunal 9 Nagaon. All the records. Place this matter for a motion immediately on receipt of the records from the concerned minister.
Lordship, he is outside if any protection,
Not
Lordship.
at distance, let us.
Lordship, I'm deeply obliged.
Maple Lordship, well, the input order page 74, my lord. And relevant part, my lord, page 76, the following the document was executed, my lord. The 66 voter list, 70, my lord, and exhibit 385 voter list, and exhibit D 93, and exhibit D, my lord, exhibit D 97. All the voter list was executed, my lord. And petitioner name appear along with his father, my lord. And petitioner fathers also deposed before the honorable as DW2. And the concerned Gaubhura also deposed as a DW3, and headmaster also deposed the honorable courts, my lord. On the discrepancy is there, my lord. The age discrepancy. The petitioner name along with his father name in 95 to onward voter list. Petitioner name appear with his along with his father name, my lord. And see, my lord, the relevant document, school certificate and Gaubhura certificate and father also deposed the honorable court and stated that my son, my lord. And the only grievance, my lord, the age discrepancy, that is 78 para 15, my lord. And that discrepancy is mentioned in the our written statement.
Read the. Please take your seat, Mr. Heard Mr. H.L., counsel for the petition. And Mr. G. Sharma or Mr. Pine will appear.
Yes, Pine was here, Lordship.
J. Pine, standing counsel home department. For restaurant numbers 3, 6. Also heard. Mr. H. Police and counsel, Planet Council, one of Mr. A. standing counsel, election commission in the restaurant number 2. And Mr. P. Sharma, additional senior lawyer for the Assam for restaurant number 5. By the imprint order is 31/08/2023, passed by member of Fairness Tribunal Bajali in FT case number 1033 of 2017. The petitioner has been declared to be a foreigner under the Foreigners Act 1946 who had illegally entered into territory of India, Assam, from the specified territory on or after 25/03/1971 without any valid documents. This satisfied, it is said in the opinion We improve order and opinion initially, right, but we improve order and opinion. Dissatisfied with the said impugn opinion dated such and such, the petitioner has filed this writ petition. Before proceeding further, we propose to peruse the records in original pertaining to FT case number 1033/2017. Wherein the impugn orders have been passed on 31 by the Furnace Tribunal Bajali in FT case number. And they said FT case. Call for the records of the sentence. And list the matter for motion immediately on receipt of the records of the said. Yes, from the current. Impugn orders will be considered on the next on perusal of the relevant records. The interim order.
For admission, item number 16.
Please, Your Lordship.
And Mary, sir, and Manopra also, re-verification regarding the petition number 2. Petitioner number has already been, but it is amendment.
In this case, Your Lordship, the petition number 1 has already been deported.
Yes,
Now-
Mr. Sharma, the petition number 2, Habibullah. There is a re-verification process, whether it is from Myanmar or not.
Oh, yes, that's it.
That we wanted to know because earlier the Deputy Solicitor General of India took time
Yes, Lordship.
to apprise the court about the status of the said re-verification process.
Yes,
Tell
Lordship.
us,
Had to.
had to inform Mr.
RKD Chopra.
Yes.
But as per my instruction, Your Lordship, in last occasion, it was not for verification. It was for hot process has been initiated for deportation of the petition.
That's true. Re-verification and whatever process they have the instruction.
Always.
Lordship, in this matter, Lordship, MSP Bora is there, Lordship. MSP Bora is there, Lordship. Lordship, MSP Bora could not appear before this honorable court due to some health issues, Lordship. And Lordship, some instructions also needs to be taken, Lordship, and therefore Lordship may grant some time, Lordship.
Matter of 2017.
Lordship.
Have you seen the order sheet?
No, Lordship, as per MSP Bora informed me, Lordship.
No, have you seen the order sheet?
No, Lordship.
Have a look at the order sheet.
Lordship.
How many times the matter has been listed? What were the order passed?
Lordship.
Mr. Sharma,
Yes.
4 occasions the matter has been listed. What were the orders passed? from 2017.
Since 2019, Lordship.
And the impugned opinion is of which year?
Mm, 60,
Which year?
Lordship.
You also don't have the file, sir.
Yes, yes, I have Lordship.
Opinion of which year?
Lordship,
Opinion of which year? Which opinion you are challenging?
Reference was
Lordship,
IMDT
ex-
reference in the year of 1998. An opinion is Lordship.
ex parte order is, ex parte order is.
2008, Lordship.
2008.
Lordship,
When have you filed this writ petition?
17 Lordship,
2007, after 9 years.
Lordship. Then Lordship,
What is your explanation of 9 years?
sir, Lordship, I am not fully aware, Lordship. I'm sorry, Lordship. I will inform her, Lordship.
9 years. Around 13, 17. No, no, I got no time. On Friday.
Lordship, deeply obliged, Lordship.
Your name?
HP Nepal, Lordship, on behalf of MSP Bora, Lordship.
This petition. Filed on 1906-2017. Is against the order dated 1302-2008. Passed by the Foreigners Tribunal Second Nagaon Appeal Act case number 278/06. Whereby the petitioner has been declared to be a foreigner under the Foreigners Act 1946, but illegally entered from territory of Bangladesh on or after 25/03/1971. After issuance of notice in this case on 23/06/2017, on the prayer of the counsel for the petitioner, the matter was adjourned on 28/05/2019. 28/11/2019 and 3/01/2024. On 29/11/2023, the petitioner remained unrepresented. Today, Mr. Nepal, Learned Counsel, appeared on behalf of MSP Bora, counsel for the petitioner. Again, sought for adjournment. List on. Saturday.
Deeply obliged, Lordship.
You will not be here, somebody else will be here.
My pleasure. Okay, in opinion is Annexa 13/641. There is no direct link evidence, my lord. However, 3 DWs have been examined, including the petitioner. My lord, one Kapansat secretary who has been examined as DW2, my lord. 3, my lord, DW3, Chittoranjan Das.
That was the official committee, Taragati. By order at the 24/07/2017. The court, while issuing notice, call for the records of FT case number FT/5/153/MA/16 from the Foreigners Tribunal number 3, Gwalpara.
Fifth, my lord.
Office note. Reflect that the said records from the concerned Foreigners Tribunal has yet not been received by the registry.
Issue reminder to the Foreigners Tribunal, Golpara. Foreigners Tribunal number 3, Golpara.
3 or 5?
Fifth, my lord,
Five.
55.
Here in the first order, it was written 3. Therefore,
That's by fifth, huh? Fifth Golpara, don't write third. Fifth Golpara. So reminder. The Subenda Police Border, Golpara. Response number 4 shall also do the needful. Informing the Foreigners Tribunal number 3, Golpara. The records of the same. Case numbers are copy of this order be furnished to Mr. Z. Sharma, standing counsel from Department of Assam for the response number 2, representing response number 2 and 4 for his necessity. However, in the call for the records of that and the FP number 3 is, however, in the order it is, we can write simply this repetition is the order is against the order. In the order dated 24/7/2017. Foreigners Tribunal 3 has been wrongly mentioned. Foreigners number 3 Golpara has been wrongly mentioned instead of Foreigners Tribunal number 5 Golpara. এখানে আনাইছে কিন্তু কারে করে দিয়ে এই সাইকেল খুশি করে দিয়ে তাহলে উঠিয়ে দিয়ে ছেলেগুলো কত খেয়েছে Publishing notice on 23/2017, records of FT/L/ case number 285/2015 was called for from the Foreigners Tribunal. Number 7, no wrong. At long time. Question not with me. Just a reminder. Mr. Z. Similar, actually loader. The police border for Jainoga. So, also inform the superintendent, Foreigners Tribunal, Jainoga. Yes, thank you. Thank you. Yes, you know. Yeah. Tonight. Now, they want this.
Who's for the petitioner? Lordship. Council, case in a.
Case D. Gugoi, P. Burua, and Burua.
Difficulty তাতে হয় নামবিলাক দিব লাগে ফোন নম্বৰ দিব লাগে similar Superintendent Police already have possessor also informed the concerned forester. Mr. Z. Sharma, study council from the department. Agree for the election and numbers 2 and 3. Shall also apprise the foreigners tribunal Ozai at some number about the records of the system. Of this order. Mr. Sharma.
Yes, Doctor.
Is this matter immediately on the receipt of it? Along with that. The next date of listing of the matter. The petitioner shall apply the court as to when. He said he had appeared. He appeared before the Superintendent Police Board. Ojai. Person to the order dated that notice of motion it was this. Same. While issuing notice on 25 July 2017. The court called for the appeal from the file of the case number 453/2016 from the Foreigners Tribunal 7th. Lonka ho jaye. This number to ready. This number to similar to the last year, but there is all for the records. The Superintendent Police Board. As I said, also the president, such as expired about the state. Mr. G. Sharma, standing counsel from department, representing this one number 2 as well as this one number 3. Also informed. As we board our project. As well as the council finance copy of the further numbers. On the next date of listing of the matter, the petitioner shall apprise the forest superintendent. She appeared before the Foreigners Tribunal for the Superintendent Police Board Ojai in terms of the order dated 25 July 2017. Oscar languages.
21.
It has certain. I was 29 also. Eleven twelve.
Yeah. Nineteen months. Notice in this case was issued 11/12 on 19/01/2018. Call for the record that FT case number 568/ZKG /06 from the Foreigners Tribunal within Wicket Roman to Greek. Wherein the said tribunal by the England judgment and order before 11/22/2011 who find the petitioner to be a foreigner under the Foreign Act of 1946 who had illegally entered into
Why are you agreeing? Which part of the opinion?
Actually, my lord, the file is not with me, my lord. Next week, my lord, on any day, my lord.
See, you were held to be within the street prior to 71
Yes,
and a direction to register your name.
yes,
You may still be aggrieved, that's a different matter.
yes.
You are not with the, you are not the council.
Yes, my lord, my name is there, my lord, but file is not with me, my lord.
17th matter file is not with you. What is this?
Next week, my lord.
On Saturday, 17th. On the council for petition. Placed on 17th.
Saturday.
Right, legal order. My lord, this matter pertains to custodial death of the petitioner's son, my lord. And pleadings have been exchanged. And the matter is ready for admission hearing, my lord.
Has some inquiry been done here?
Additional district magistrate has done some inquiry, but my lord, the inquiry report echoes whatever the police has said, my lord. If your lordship come to the postmortem report, which starts at page 46.
Inquiry was done after examining witnesses.
No, my lord, there is no witnesses because the incident occurred in the late night, my lord.
Witnesses doesn't mean eyewitness.
My lord, the police personnel were there.
Their statements were recorded.
The inquiry officer says that he visited the place of occurrence and as well as the statements were recorded.
Mr. Rafiq, you are from whom?
Milord, I am appealing for respondent number 8, Milord.
IO.
IO. But I have not received the copy of the reply, Milord. They have filed the reply.
At page 50 of the writ petition, there is a part of the postmortem report, page 50. Last page of the writ petition. Opinion regarding cause of death is kept pending till the receipt of chemical and toxicological report from BFSL, Khanapara. However, the injuries present over the body were antemortem and caused by blunt force impact. So it is apparent that though the authorities are trying to project the case as death as case of drowning, however, there are injuries marked which are caused by blunt force violence. And at page 46, the wounds are reflected.
Please read the physical injuries.
It's at page 46, my lord.
Yes.
The second column, wounds, position and character. One lacration measuring so and so centimeter,
No, not so and so, 2 centimeter,
2 centimeter into
0.3 centimeter, and
Yes.
skin deep.
skin deep.
This is a very, very minor kind of a lacerated injury.
True, my lord.
Next. No, what you are indicating that as if that he was tortured. He was killed and it was made into look like as if it's a case of
My
drowning.
argument is on two limbs, my lord. First, the postmortem report says there were injuries in the body which are antemortem in nature.
That is what we are trying to examine.
Yes.
What are the injuries?
And my lord, the second limb of argument is that the authorities are trying to project the case of drowning. No, my lord, so how the victim drowned, my lord, this is under serious doubt, my lord. Because they say they took the victim to conduct a raid, but they were not equipped with any torchlights and all. And in the midst of the
See, you are trying to project your case or build up your case, which are totally on facts. Facts, neither you can say with authority nor we can accept
lord.
anything.
My
So
lord.
that is why a fact finding exercise have been done,
My lord,
which is in the form of a report, inquiry report.
my lord,
Now, that inquiry report is for us in a writ jurisdiction to accept or not to accept.
true.
You can certainly make your arguments that these are lacuna for which
That,
this cannot be accepted.
that would be my
And
endeavor,
that those lacuna has to be apparent on the face of it.
my lord.
We cannot go into a roving kind of an inquiry.
Very true, my lord. Very true.
Because you see, most of the custodial case compensation are granted based on the inquiry.
True, my lord. True.
So it's not that inquiry is made, we do not accept. We accept or we not accept, depends on the kind of inquiry, the report, who are the witnesses who are examined.
My lord,
Is it based on materials and records?
my lord.
Only the decision making process in the inquiry.
True, my lord.
And though the inquiry per se is not the subject matter of challenge,
True, my lord.
it is in fact part of the proceedings before us.
True, my lord.
To come to a just conclusion, because in matters of this kind where custodial debt is alleged,
My lord.
based on Nilabati Behar and all those cases, we say that let a fact finding exercise be done only on the seriousness of the matter which is before. Otherwise, even a fact finding inquiry is not contemplated in a writ court. But if there is an inquiry report, unless you make it an exceptional case that inquiry report cannot be accepted as a whole. The burden is entirely upon you. Where is that report?
My lord, they have annexed with their, one of their affidavit, my lord.
Last page, number.
It was filed on 24/2023.
Recovery report, my lord, in affidavit, we have filed one affidavit, page 61, 62 minutes.
Running page 61, madam.
There were 10 numbers of witnesses.
But all police personnel.
Family members and relatives were deceased.
No, they were not present, my lord, because he was being taken.
Their statements were recorded.
Statements were
Nobody could be present from your side.
The statements were recorded. Unfortunately, the first finding is my lord judgmental, because he was not even produced before the court.
You come to page, page 5 of the affidavit, internal page 5, which is running page 111. Because that opinion which you are relying is prior to the final report. The final postmortem report was proved by another officer, another medical officer, Asim Tehran.
Yes, my lord, that was a preliminary report because the report of FSL was still
Yes,
awaited.
after that, what had come is something different. Please leave that. Incident page 5 is this. He was examined as witness number 28.
My lord is referring to affidavit filed by my lord.
This report, you can come to the report directly. You have the copy of the report. 21st of April 2023. By the response number 4. Additional affidavit. Or if you have a copy of the report, you must be easier for you. You don't have a copy of the report.
My lord, that final report I don't have.
No, not the final report. The inquiry report.
Inquiry report I have, my lord.
7 to 2023.
5.
7 to, do you have 7 to?
7/2/2023. Please take it. Yes.
Judicial Magistrate First Class Hajo.
Yes.
This one is Superintendent of Police. Yes, 5.
Have you got it?
My lord, one affidavit filed by Hitesh Chandra Roy.
Yes. You come to the internet page what?
5.
5, I think. No. The report, it has got the report.
Yes, my lord, para 5.
7 to 2023.
Para 5, my lord.
You come to the report first, second, third, fourth, fifth page of the report. 5th page of the report. 5th page of the report. Opinion of the medical officer on receipt of final postmortem report.
Postmortem report. Yes, please.
Move from the administrative Diana.
Do you have a copy of the report 7 to 2023 with you or not?
My lord, the enclosure is not there. I have the affidavit.
Enclosure is not there.
Enclosure is not there.
Yes, again.
Yes, my wife got it. It is there.
Yes.
Got it.
It is there, my lord.
We'll come back at 2 o'clock.
To mention item 14, Lordship, kindly adjournment for the day, Lordship.
Is this the time for mentioning?
No, Lordship, but
Then-
senior has left.
If you know it's not the time for mentioning, don't mention now. Mention when the matter reaches. It's not an exceptional mentioning.
Yes, Mr. Patori. Yes, well, I have gone through that judicial inquiry report. And my lord, one vital aspect which is missing in the report is that how that drowning occurred, it is nowhere it is mentioned, my lord. The inquiry officer simply accept that yes, police has said he has drowned and I accept that. The family members raised that objection because they could not produce any evidence, so my lord, their concerns were negated, my lord.
So see, your entire projection is based on a suspicion.
Yes,
That
my
it
lord.
is a matter of custodial death.
Yes, my lord.
There is no eyewitness, obviously there is no
Yes.
from your side
Yes,
to substantiate that projection. You think, you suspect.
yes,
Now there are rebuttal evidence. On the other hand, on the other side, you cannot make an argument that since nobody, the police personnel has said, you can make an argument that those statements are not reliable. But to make an argument, you have to have some basis. Their statements were recorded in your presence.
my lord, the statements are recorded,
It was recorded by a judicial magistrate, it's
True,
a
my lord.
judicial inquiry.
my lord.
It is not an inquiry by an executive officer or
Yes.
something like that.
Yes. Lordship, if your lordship kindly comes to page, running page 59, internal page 6 of that judicial inquiry report, my lord,
5-9.
59 running page and internal page 6, part of that judicial inquiry report, my lord.
5-9 starts with the affidavit.
No, my lord, they're the same inquiry report you lordship were referring to in the pre-lunch session, my lord. Additional affidavit filed by Hitesh Chandra.
affidavit filed when?
On, I received it on 24/2023,
That's that last affidavit.
last affidavit.
Yes.
That judicial exam access report, my lord.
Yes, that is the page number, that's not 15.
It starts at 54, marked as annexure A,
That starts with 104 for us.
my lord.
Internal page is 56, your internal page. 56.
My page is 59.
59, okay, we have 59 also. Here, one. Where,
My lord, it is under the column my opinion and findings thereon. My opinion and findings thereon. It starts under that column, my lord. Lordship will kindly turn to the next page. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10th line from the bottom.
next page.
Yes, 10th line from the bottom.
Yes,
The postmortem report states
yes.
that the death was caused due to asphyxia as a result of drowning, and it corroborates with the statement of witness number so and so, so and so. And where are these witnesses? There is no list of witnesses, no one is there. Who are witness number 1, who is witness number
There, it
2?
is there.
Well, my lord. He is a judicial officer, my lord.
Notice was given to all.
The notice was given to all, but who is this witness? How can we relate, my lord? Who is the witness number 1? Who
We
is the
can have
witness?
a look at the procedure, at the records, that's not an issue.
Anyway, my lord.
Records of this inquiry. Come to paragraph, page 56.
57.
56.
Yes, I have summoned all the said officials.
Then, not only someone, I recorded the statements of Sanjeev Boro.
Yes.
So it's only because the numberings are not here, you cannot say that it's not based on no evidence.
No, I am not saying that no.
We
evidence.
just need to
I am
collate,
trying
collate.
I am trying to pursue a lawsuit that some sort of, my lord, perfunctoriness is there. My lord, is cast a doubt, my lord, because lordship will kindly see, a 20-year-old boy lost his life, and the reason sought to be ascertained is by drowning. Was it not incumbent upon the judicial officer who conducted the inquiry to at least state what was the depth of the water, whether it was sufficient for drowning or not? That is not even mentioned, my lord. Now, lordship, kindly go, let me complete this paragraph, my lord. The postmortem report states that the death was caused due to asphyxia as a result of drowning, and it corroborates to the statements of witness number so and so, so and so. And the witness number 28 has clearly mentioned the meaning of the term asphyxia and drowning in his statement, which is kept with the record. Moreover, there is corroboration in the deposition of the witnesses mentioned above that the deceased jumped into a water body, and on prolonged search, he was found unconscious. Also, witness number 18 has stated that Sanful Ali, that is the deceased, my lord, was hiding in Lakhimpur to save himself from police, from where he was arrested. And as such, it can be made out that Sanful Ali tried to escape. Now he is resorting to presumption. It can be made out that Sanful Ali tried to escape by jumping into the
This
water.
is not a criminal trial, Mr.
True, my lord, but a
Not a
life has been
criminal
lost.
trial.
I
It's a
understand.
fact-finding inquiry.
I understand. I bow down to your lordship, but lordship kindly see,
The
lordship
standard of proof beyond all reasonable doubt, that will not apply here.
not apply, but minimum something has to be there.
No, 15 witnesses have been examined.
Or
Statement state, postmortem is against you. You wanted to make out a case on the postmortem, final report is against you.
true, my lord, I am not disputing, my lord. Though the family members of the deceased suspected foul play in the death of Sanful Ali, there is no evidence on record to establish their suspicion, my lord. The family members, as they were not present, could not have declared
You
any
can
evidence.
very well challenge this. This has been done only to facilitate us to come to a just finding. You can challenge it, but the challenge has to be proper in a proper manner.
True, my lord, because the IO who was
You
living,
are still have the liberty to persuade us not to accept this, which
Yes.
you are trying to do. But
my lord,
perhaps we don't find that this is so obnoxiously or something which is totally a perverse finding has been arrived at. Yes. One more. Even sir. Oh, this is ministerial inquiry. What is the finding of the ministerial inquiry?
my lord, that is, he said that, my lord, he visited the place of occurrence at the page 65. I don't know what your lordship
Yes,
said.
same page.
Observation, the EO self-visited the place of occurrence where the accused tried to flee and was drowned. On observation, it was found that the tributary is deep, and on observation, my lord, how he observed, it is not known. It is found that the tributary is deep and there is a strong undercurrent in the flow. A person of 6 feet height can easily be drowned in the water, and the height of the accused is not more than 5.2 feet. The tributary is also marshy, and at places bushes are seen, which can easily tie a person who is not an expert swimmer. The incident occurred late at night. At 2 a.m. it occurred, my lord. And no neutral witnesses are to be found in the proximity. There are no houses in and around. Inquest had been conducted by the CO North Guwahati, and nothing suspicious is reported. Even in postmortem report, nothing alternate is found. It is pertinent to mention that the tributary where the accused jumped has huge quantities of thorns, branches, and boulders on either side.
Who is for the government?
Mr. Dinath will apprise the honorable court. He is on platform or number 2, Lordship.
Okay, no, today, today we may not take up for final disposal.
Lordship.
We'd like you to have the records of the inquiry. Just, you have given an affidavit. There is no rebuttal, anything, but still then, we'd like to see the procedure adopted in the inquiry, and we fix for disposal on a date which is convenient to both the parties.
Lordship.
Next week, yes. Records will come from which place?
Hajo.
So it's Kamrup district. You get the records immediately. We'll have it this. This inquiry was pursuant to an high court order.
No, the district judge order, my lord. Which order? Which inquiry?
The inquiry.
Judicial inquiry. Yes, my lord. Under verbal direction of the CJM. On the top it is written.
That we have seen. But CJM gave this order why?
That is not known, my lord. It will be evident from the records.
Why was this inquiry made? Government council?
Lordship.
Why was this inquiry made?
I have to go for the record, Lordship. So, Mr. Dinath will apprise the honorable court.
See, an official inquiry on verbal orders
Definitely, Lordship.
definitely will not be made. There has to be something else. Was it a petition made or something, or where is the main case pending regarding his death? He must have filed a criminal case also.
Lordship.
Have you filed a criminal case?
My lord, the officer in charge who took the victim, my lord, he lodged an FIR after the incident occurred, my lord.
Against whom?
No, reporting the incident, not against,
Oh, he reported the incident.
my lord.
Have you logged any FIR?
My lord,
You take instructions on.
My
that
lord.
regard. Maybe it is a result of that FIR also.
that report is at Annexure 5, my lord, page 44 of the writ petition by the IO.
No, or merely on the basis of a report.
It was lodged before the Judicial Magistrate First Class Hajo at page 44.
Mr. Nath, are you equipped with the information and facts? How did it proceed? Why this inquiry was conducted?
But the
The prelude of the inquiry suggests that there was a verbal direction of the citizen. In connection with what?
Mr. Nath,
ministerial inquiry, lordship is indicating.
not
based-
the ministerial inquiry,
Okay.
the judicial inquiry. You have filed an affidavit,
Yes, madam, we have filed.
and the last affidavit filed on 21st April 2023.
Yes, sir.
Come to page number, internal page, which is 4. It is, in our record, it is 107. Submitted by the JMFC Hajo
Madam,
on 7th of February 2023.
yes.
What is the requirement for submitting that judicial inquiry report?
7 to 20, yes, madam. Yes. Madam, but the requirement I have to see, madam. It indicates that as per the verbal direction of the landed stadium. What, 176, 80, 176. 176, CRPC, 176. Equals 76, 176 equals. Well, it is under 160, 176, 1A. Madam.
Yes, that is what we were.
Yes, paragraph 3 we have studied. Madam. Page 52. Madam.
Mr. Nath, we are just expressed that we would like to have the records of this inquiry.
Lordship.
And since today is not, though we can dispose this of or hear, go for final hearing, that Mr. Patwari also come prepared with case law.
Yes.
We may indicate that this this inquiry, which is no doubt is under 176.
76.
But this is in the has the color of a judicial inquiry,
Lordship.
which is normally directed by courts, real court, examining matters of this nature, where compensation or anything is paid for custodial death or anything. So we have a copy of the inquiry made by the judicial officer
Yes.
after recording of evidence. He is trying to point out some informative. How much will go into the informative unless those are absolutely perverse to the materials available. For on the basis of such inquiry, we are giving compensation. So normally we go by the veracity unless the burden is upon the person who really says that it should not be taken into consideration. So here inquiry seems to be in your favor. So the onus is upon him. And unless he discharges the onus, so perhaps we may not even require to hear it. Okay, now we fix a date. There are cases you can. And in the meantime, we call for the records of the.
The inquiry conducted by the judicial magistrate, it will be from the judicial magistrate court, no?
Yes, yes.
Lordship.
We'll get it from the registry.
Registry will do that.
Heard Mr. J. Patwari, counsel appearing for the petition. And Mr. Dina, Senior Government Bukit Assam. For all the official respondents number 1 to 7. Also heard Mr. You are appearing for 7, right? 8. I Rafiq, Learned Counsel for the respondent number 8. With regard to date of one Sanful Ali, son of the petitioner, allegedly under police custody on 03/12/2021. The judicial inquiry was made by the judicial magistrate first class Hazu in Miss case number 02/2022 under section 176 put in bracket 1 capital A bracket close of the Code of Criminal Procedure and submitted the report on 07/02/2023. Registry shall call for the records of call for the records of say Miss case number 02/2022 from the JMFC Hato. Unless the matter again on. Registry shall procure the said record forthwith and shall list this matter for admission immediately on receipt of the same
Deeply.
Zero.
Please, Your Worship. So this is an application for
Yes,
modification.
Mr. Payang, earlier we asked Mr. Kalita, what is the information you have regarding the registration of the petitioner? Whether he is validly registered his name or not? For the FRRO? No. The matter has been listed after more than 4 years. You may not have the instruction, so have
Yes.
it if you do not have now.
Let it come in the next week, madam.
Give us a date,
On 22nd.
but no further time.
Yes, ma'am.
Miss Kesat order to assume another.
I have to touch it.
Mr. Dutta, how you drafted your petition? Under what provision? I. Is under 226.
So it is an outcome of writ
So it's a
petition.
petition under 226. You are not new member in the bar. Can you dispose of repetition, miscase not maintainable law done by the apex court long back. Matter is disposed of, I is not maintainable, at best a miscase for restoration, you are praying for modification. And you say that application is under Article 226. We are addressing reported judgments. There would be circumstance where you may file, but it definitely will not be an application under 226. Contrary with the Indian Airlines. But if we say in some circumstances. It is possible. Exactly. You can file. Our work is to. Yes. Supreme Court judgment. Yes. It's very clear. Dispose of case of material question. That depends actually. Extension only can be given. Only when during the process. Indian Airlines for review. Consent correction. Our High Court judgment is so. Respondent who he was Brahmodat. You read Brahmodat Sharma and K answer it.
Lordship, I have in fact gone through it, but somehow I have read petition once disposed, it cannot be reopened.
Then,
No, we can, on circumstances. we
Yes,
can.
Lordship,
Okay,
yeah.
read K answer.
Yes, Lordship.
K answer versus Indian Airlines.
Yes, Lord.
And
Lordship.
Brahmadat Sharma has been beautifully explained.
Lordship. In fact, this is an application for clarification, Lordship.
Verification you can,
Yes, Lordship.
but not application as 226.
Yes, Lordship.
Okay.
Because Lordship, during the pandemic initial stage, he was directed to register, Lordship. In pursuance to the court order, he has approached the.
See, you cannot be, you will not be left remediless. You
Yes.
have the remedy, but
Yes.
you need to follow the proper procedure.
Lordship,
You just cannot barge in and file a petition at 226.
Lordship.
The connotation of 226 is totally different.
Yes,
It's a fresh petition.
In our opinion, in the case, no press release on the basis of the news for the website that we got. The press for the clarification. In our judgment, revision wasn't error in believing that after this revision explains people are not trying to that and the remaining members of the Indian. Yes, I was filed on the 6th of November, September 5th. Register 130 days, যদি 30 days not করে, you will be deported on the India. এখন কেটে হয় এখন নভেম্বর 2 months later 2 months later এনেকে পড়েছি না এরা 2 months later ফাইল করছে আর ইনোভেশন register করা হয়ে গেছে as per the order of the tribunal. Okay. He has registered on 6/12/2017. Verify
Have you registered?
Lordship, I have registered, Lordship, and I have even.
Then what is your difficulty now?
Lordship, again, direction was given to the petitioner to register itself, Lordship.
Once you have already registered.
Yes, Lordship, because it was not informed to the council, Lordship, and accordingly, at the time of hearing, Lordship, we could not point out the same to the honorable court, Lordship. Only that modification is, Lordship, required. Because
Can you verify the projected case of the petitioner that is already registered pursuant to the direction of the tribunal?
I'll verify.
In that case, the earlier petition itself perhaps was not even a cause, without any cause of action.
Yes. I'll get it, but.
But this matter, the pending is very long.
Probably it was not listed for long, my lord. That's why.
No, we have to change this system.
Yes.
All cases.
Let it come on 22nd, my lord, get the entire.
Mr. Payne, see, there is an order of 1st of November 2017 directing him to register. And thereafter, the final orders have been passed, again directing him to register within a period specified. It appears that prior to the first direction, he got himself registered, which was not brought to the knowledge of the court while the repetition was disposed of. And so the 1 month time was done. Now, there is a document.
Yes, there is a
which
document.
Shows that he's already been registered. There's no question of second time registration.
That's,
You can get the information.
yes,
That's fine.
that must be. I will get the information whether he is registered or not.
You have a copy of the miscase?
Yes, I have.
You have then page 10.
Page 10, I have got it.
That is the issue.
That is the only issue. I will get on 22nd, my lord.
On the prayer of Mr. J. Payne, standing counsel, Home Department. Place this matter on 22/02/2024. Enabling him to apprise the court as to whether petitioner / applicant of the writ petition duly submitted the necessary applications for registration of his name on 06/12/2017 under the provisions of the Section 6A of the Citizenship Act 1955 or not.
I will like.
Lordship, in this matter, draft affidavit is ready. One letter has sent to the SP Nagaon for swearing. So I may be allowed to 1 week time for filing the affidavit. Lordship.
Tell us when.
1 week. Lordship.
Give us a date.
20 of
Notice
February.
was issued on July 2022.
Lordship.
We are in February 2024. Give us the date. 1 week from today means
20 of February.
it is submitted by Mr. Sasitas, Government Advocate Assam. That. Notice in this case was issued on 18/07/2022. And the state respondents are yet to file their affidavit. The Beckett has done. Mr. Sasitas, Government Advocate Assam. Submitted. That affidavit is on behalf of the state respondents shall be submitted. With file on 20/02/2024. Hence, wait for amendment of the marriage. Placed on 21/02/2024.
Right, Lordship. Thank you, Your Honor.
Please take your seats. Yeah, but who's appearing for the respondents?
Lordship, I'm for responding on 1, 2, and 3, Lordship.
What is it?
Yes, Lordship.
File your affidavit of
Yes,
time.
Lordship.
Yes, who is applying for the government?
Detention order to say this here, no?
It's the central government.
Yes, madam, I'd like to file a rejoinder affidavit.
Your Lordship, we have not we did not get the affidavit from the
You have
government.
not received the copy.
No, Your
It
Lord.
is filed on 10th.
No, we've from the union we've got. From
Your
the government.
grievance is against whom? The union or the state?
Your Lordship, It's it's against the union, also the state has some duty.
What is the role of the state? Nothing. What is the act concerned? Prevention of illegal traffic in NDPS. It is the states, the unions or the. They have filed a, would like to file, would you like to file any rejoinder?
Your Lordship, my senior is on legs. Kindly give an emergency.
No, you should have taken the instruction. It's not a question which has just emerged. It's a question which should obviously coming from us.
You have the repetition?
Yes, Your Lordship.
Come to page number 72. Read that order.
Whereas I, Ravi Pratap Singh, Joint Secretary to the Government of India, specially empowered under Section 3(1) of the Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substance Act 1988, am satisfied with respect to the person known as Mohammed Shuhud Ahmed Laskar, that with a view to preventing him from engaging in illicit trafficking of narcotics, drugs, and psychotropic substance in future, it is necessary to make the following order. Now, therefore, in exercise of the powers conferred by Section 3(1) of the Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substance Act 1988, I direct that the said Mohammed Shuhud Ahmed Laskar, son of so-and-so, is detained and kept in Guwahati Central Jail, Guwahati, Assam.
Now, who has issued this order? At the top,
Government of India,
Ministry of,
Finance,
in which department?
Department of Revenue,
Order, which date?
27/12.
Come to your prayer. At page 30. It starts at 29, basically at 30. Whose order you are challenging? It's there, everything is there.
Yes, Your Lordship.
Whose order? The order just now you have read, right?
Yes, Your Lordship.
So it is the Union of India, not the state government. So brother is asking you, are you going to file any rejoinder to the affidavit of the Union of India or not?
Yes, Your Lordship.
It is not for us to say yes or no, it is up to you. It was served upon you on 10th of January 2024. As for the notice we have here. Have you submitted any representation after service of this notice or not? Have you filed any representation? Are you aware?
We have received the copy.
Verma, NDPS. Where is your book?
I cannot bring it.
Not like this. It's no fun to stand here. Is it fun? Why don't you have the book?
I have the book, it's in the back.
Where? Bring it.
Lordship may fix a date for hearing. I will require my senior.
Given a chance, you try to read the book. What is the difficulty, madam? Are we deciding anything against you? Getting a chance, read out the text. Where is the communication order? Madam? Period of delivery is already over. Yes, the period is also over 1 year. Today is 12th. How about it over 18-1? No, 18-1. Oh, yes, 18-1, 18th of January. We're in February, yes. Madam Gan, you here
Hello.
in this matter?
Yes, ma'am.
The confirmation order after the approval by the advisory board
Yes, ma'am.
was for 1 year
Yes, ma'am.
from 18-1-2023, which is over.
Yes,
So what is now? What is and you have filed the affidavit after that on 10-2. 10 January. 10-1. 10-1. After that,
10-1.
what has happened? 18-1.
My lord. My lord. Only take up for the time being, man. I was time being, man. I wrote for the paper. Time being.
Also inform us whether still in detention.
Yes, ma'am.
We'll take it after 5-10 minutes.
10 minutes, my lord. I wrote.
You take the telephonic instruction.
Yes,
What has
madam.
happened? Maybe she is already released.
Yes, my lord.
You also take information.
My lord, in this case, my lord, my lord, mistake was, my lord, taken place in the order, my lord. Kindly come to page 9, my lord. In the order. Second paragraph, my lord, line number 2, my lord. Superintendent of Police Borpeta, your and district Borpeta. My lord, Borpeta should be Nogam, my lord. And another mistake, my lord, at page 10, my lord. Paragraph to line number 3, my lord. FT case number 246, 2016, but it should be 264, my lord, instead of 246. And another estimate, my lord, kindly come to page 13, paragraph 11. Opinion dated, my lord, 27/12/2018, but it should be, my lord, 24/4/2019. These three mistakes, my lord, committed in the.
It's a fact. Typographical error.
Yes, yes.
We have checked the main
My lord,
petition. Very specific.
Yes.
Order is of 24/4/2019. FT case is 264 of 2016, and it is foreigners tribunal number 4 Nagaon Duria. Only the place which should be Borpeta, that should be read as Nagaon Duria. FT case number is 264/2016. It should now wrongly with 246.
Yes.
And it is 24/4/2019, but in the order it is 26/4/2019, right?
Yes.
That much should be corrected. On being referred by the Superintendent of Police, Order Nagaon. Learned member of Foreigners Tribunal. Court Nagaon Juria. In by order written 24/04/2019 in FT case number 264/2016. Appoint the petitioner. To be a foreigner. Under the Foreigners Act 1946. Agree with the said opinion. Dated 24/04/2019 of the Foreigners Tribunal Court Nagaon Juria. The petitioner preferred the connected writ petition WPC number 4009 petitioner, the applicant has petition. Preferred the connected writ petition WPC number 4009/2019 that was disposed of on 29/03/2023.
My lord, 15/6/2020.
15/6. 2023. In the said order dated 15/06/2023, WPC number 4009/2019, inadvertently the FT case number 246/2019.
16 million.
Sorry, 2016. Have been inadvertently, don't write, inadvertently typed as 246/2016. Moreover, in the said order dated 15/06/2023, instead of Foreigners Tribunal Fort Nagaon Juria, it was mentioned as Borpeta, Foreigners Tribunal Borpeta.
My lord, Superintendent of Police, Borpeta. My lord.
As Superintendent of Police, within bracket border Borpeta. What else? How do you say 3? There are three mistakes you see. The last court order, 27/12/2018. The last page,
Paragraph 11, my lord.
27/12/2018 to open.
The opinion dated 27/12/2018. It should be
The
24.
earlier opinion.
Next.
Where is the earlier opinion? You have annexed in the repetitions.
My lord, annexer 1, my lord, page 8, my lord. This is the final order, my lord.
Opinion of the court. Opinion of the tribunal.
Opinion, my lord, in the repetition, my lord, itself, my lord, I not annex, my lord.
Your opinion. It was not in order to the. Check for the.
I have included in paragraph 4, my lord. That will be clarified. Erroneously, the Superintendent of Police Borpeta, PO, PS, Borpeta, Assam, in place of the Superintendent of Police Nagaon, Binagaon District, Nagaon, Assam. And FT case number 246, 2016 has wrongly recorded at line number 4. Paragraph 2 in place of FT case number 264, 2016. And therefore, it is further submitted in paragraph 11 of the said order. It has erroneously been typed out as opinion dated 27/12/2018 in place of opinion dated 24/4/2019. And also prayer portion also, my lord, clearly indicated, my lord.
Pardon. The said order dated 15/6/2023 at para 11. Inadvertently opinion dated 27/12/2018 was mentioned instead of 24/04/2019. Hence, this application for correction those typographical errors that occurred in the order dated 15/06/2023, NWPC number 4009 of 2019. We have perused the records of WPC number 4009 of 2019 and found that there are inadvertent typographical errors in the order dated 15/06/2023 as noted above, to which Mr. J. Bank standing counsel preparing for the opposite, but we have no objection in correcting those typographical errors. Accordingly, in the order dated 15/06/2023 passed by the coordinate bench in WPC number 4009 of 2019, the wards, the Superintendent of Police within bracket B, Borpeta, Post Office, District, Borpeta, Assam. The following shall be corrected. 1, 2, 3, question Roman 1.
The Superintendent of Police within bracket B Borpeta, PO numerical and district Borpeta Assam shall be read as Superintendent of Police within bracket B Nagaon, PO and district Juria Nagaon. FT case number 246/2016 shall be read as FT case number 264/2016. Date of the order dated date of the earlier opinion dated 27/12/2018. Whatever reflected shall be read as 24/04/19 within bracket passed in FT case number 264/16 by the Foreigners Tribunal Court Nagaon, Juria, Assam, bracket close. This order shall be read together with the order dated 15/06/2023. Passed earlier in WPC number 400/2019. For the above observation correction, this interlocutory application stands in this program.
Obvious me.
Hello, one.
Being dissatisfied with the opinion dated 14/11/2018 passed by the learned member Foreigners Tribunal 9th Borpeta in F.T.9 within bracket BPT, that stands for Borpeta. Case number 12/11/17. Whereby she was declared as a foreigner. Under the Foreigners Act 1946 of post 1971 stream. She filed this writ petition on 22/07/2019. Impugn final order. On earlier occasions, on earlier 5 occasions, when this writ petition was taken up for consideration at motion stage, on 1/10/2019, 29/09/2023, 19/10/2023, 29/11/2023, and 08/12/2023. Learned counsel for the petitioner took adjournment. In the morning, when this matter was taken up for consideration, the petitioner remained unrepresented, though name of 3 counsels for her was has been reflected in the cause list. In the second half, when this matter was again taken up for consideration, the petitioner remained unrepresented. Accordingly, this petition is dismissed for non-prosecution. Yes. That Myanmar issue.
Yes. Probably in this case, my lord, Mr. RKD Chaudhary will appear because from us, we have sent the proposal, my lord.
What happened?
No, the central
The
government.
information given to you by Mr. Rakijit.
No, my lord,
Place tomorrow.
Lordship, not on tomorrow, your lordship.
Thursday. Thursday. List on
All right.
15th. And on this side, that Mr. R.K. Chaudhary, Deputy Superintendent, Solicitor General of India, shall apprise the court the relevant information that was sought for by the court earlier on 20/07/2022 as well on 31/08/2022.
All right.
In this case, detention period has been over, my lord.
What happened? Where is he?
He is in jail, but not in this case, for some other case, my lord.
Can you give us the number?
My lord, NDPS case.
In this case, lordship, 180, NDPS 180
Give
by,
us the number, Miss. Gayan.
NDPS 180 by President.
Let her give the number.
Lordship.
Which the petitioner is in custody. And then
It is to my lord.
It was
Just now, telephonically, he informed my lord. My lord, kindly
we
take
want the
tomorrow.
case number.
Yeah, my lord, tomorrow I'll provide the case number. Tomorrow, my lord.
1 day detention, extra detention might cost you more.
Then, my lord, I'll take inside,
We
my
are here
lord.
up to 4.
Yes, my lord.
What case did you mention? No, no, no. Which number, madam? Gayan?
He doesn't.
Some 180 you had said, which one?
What?
Which number you had said now, some number now, just now?
No, my lord, I didn't say. My lord, I'll take instruction in which case he has written.
180 by 22.
180 by 22.
Lordship.
That is an NPS case,
Yes.
not under the prevention of NPS.
That is, lordship,
This detention is under the prevention.
yes.
It's a preventive.
He was
detention.
arrested 180 by 22, lordship. Then this prevention of PIT was imposed, lordship.
Where do you get that number? Oh. Well, then I said, where is this? Paragraph 4. Paragraph 4. And here is it.
This is right now registered as NDPS 180, but initially it was lordship. It is mentioned in page number 33, lordship. Earlier it was registered as NCB crime number.
Now, if you read your government at paragraph 4. See, one is the preventive detention.
Yes.
Okay, there is a limitation, 1 year in that order. Now, it seems that your arrest is under an NDPS regular case.
Yes, sir.
That is was Pete was there, Lordship. Because allegation is that he was arrested in earlier another case. In that case, he was convicted because of that part is over. Then he has this was imposed because of this reason, Lordship. That we need a hearing because Lordship stigma is there, though it is over, Lordship.
Now read paragraph 4.
Yes.
He was arrested by the MCB. Next one, crime number 03. Under the section.
Yes, after arresting this Pete was imposed, Lordship. It is mentioned there in their memo also. In the record, Lordship.
Page, please.
Page 33. The reference NCB crime number 3/22.
The case could have been registered.
এটা আমার কেস করেছে কিন্তু মানে একটা জেলত প্রসেসে প্রিন্সিপাল ক্রাইম and the evidence of this to আছে নাকি জিপি দেখে আছে একটু মনে জানি একটু বলে করে দিলে একটু বলে করে আমার তো কভার হয়ে গেছে আমার তো এনসিপি নাকি এটা বলে করছে একটু বলে
Yes, Ms. Gahan, get the case number.
My lord,
Which case? Presently in which he is under detention.
my lord. I'm coming at in 55 minutes, my lord, at 4 o'clock.
Give it to her.
Yes, right.
Lordship, she will be there, Lordship. Lordship. We need a hearing if Lordship wants, then next on Thursday.
We'll see before passing any order, we'll see. Whether you are required or not.
Offline.
That will go. My lord, in this case, my lord, an ex parte order was passed without serving notice to the petitioner. It 23 is the impugned order.
Did you appear pursuant to the order?
Where, my lord?
Did you appear pursuant to the first order of 3/9/2021?
3/9?
The order of this court?
Yes, my lord.
You had appeared?
Yes.
When did you appear?
Lord, okay. Daily notification should be no, within 15 days I have appeared.
Give us the date.
But the date right now I don't have no. I've executed furnished a bail bond also.
In the repetition, where is the impugned opinion?
My lord, page 23.
23.
Yes, my lord.
Where have you stated that you are not served?
Milord, paragraph 12, case 6,
Paragraph
12,
12, page.
6. How we came to know about this, Milord?
Yes, please read.
May I read?
Yes.
Thereafter, the petitioner immediately contacted his legal advisor and requested to inquire into the matter. And accordingly, through him, the petitioner came to know about the impugn order dated 19/5/2018. And on perusal of the case record, the petitioner was shocked that the impugn order was passed in total non-application of mind, and the said order has nothing but miscarriage of justice, as because on perusal of the order dated so and so, so and so, so and so, it is clearly found that the notice has not been served upon the petitioner. But the member for tribunal, filed order dated so and so, had jumped and come into the conclusion that the notice to the opposite party was properly served.
Mr. Pai, what do you say on the ex parte
Milord,
issue? We are not in on the merits.
Yes, if notice is not properly served, your lordship may remand the matter and let him appear and contest the case.
Aziz.
You appear before the tribunal.
Yes, madam, yes.
On 1st of March.
Yes, madam.
File your written statement along
Yes,
with the
madam.
document.
Yes.
Also your evidence in affidavit.
Yes, madam.
Right? Yes, we'll dispose of it.
I opted for the petition.
All as me.
Election function number 2, J prime, J prime 306. Return the records of. FT case number 96, public MKCR, public 11. The foreigners tribunal card recovery at Singimari. It is now not recovery, it will be under South Salman and Kachar.
Yes, sir.
South Salman and Kachar. Along with a copy of this one. Ini dana yang belum mereka dapat dalam belum mereka lakukan.
Lagi.
Saya lakukan mereka legal saja. Kalau punya saya lakukan. Legal saja. Mana ini? Madam Gan.
Item number 4.
May I please, your lordship, kindly list this matter after 2 weeks.
Why?
Lordship, I have to receive instruction from my client whether she is appear before this SP border or not.
Mr. Pine, we'll have it on Thursday, right? Getting instruction from the SP border Borpeta whether the petitioner pursuant to this order of 29/9/2023 appeared before him or not.
15, my lord.
15th. Get it on.
Yes.
List on 15th. One motion.
Obviously.
On the prayer of the on the said that Mr. Deepak standing counsel from the party. Salary appraisal court has to place a petition. Pursuant to the order of the 29/09/2023. Appeared before the superintendent border Borpeta or not. And if so, when. Counsel for the petitioner shall also get the information in that regard from the petition.
6.
May I please, madam?
We'll have it on Thursday. Wednesday holiday, tomorrow already list is out, we'll have it on Thursday, records are here. Okay. The prayer council for the party, yes, ma'am.
My lord, kindly come to page number 93, my lord, of our affidavit in opposition.
Sorry, my lord. I'm not available, my lord. After 23.
Saturday.
Saturday, no, I'm not available, my lord.
Since when?
21, my lord.
Will be not available from 21st of February.
Yeah.
That is why you are fixing it on 17th or on 15th. Will be available when?
22, my lord.
Okay, on 22nd.
My lord.
Page 90.
Page 93, my lord, running page. Our affidavit is 6 months, affidavit in opposition, my lord. Para number 13, my lord. The deponent stated that the detainee was involved in NCB crime 3 of 2022. On 18 to 23, NCB Guwahati team carried out search on one Maruti Desire bearing so-and-so and one Maruti Gypsy bearing so-and-so, in which the total of 12.040 kg of morphine was recovered and seized from the possession of 3 persons, namely Ataur Rahman, one of the accused here, my lord. Then, my lord, on the basis of conscious possession, confessional statement and other corroboration evidence, they were arrested on 19 to 20 days. A search sheet was filed the Court of Honorable Court, Special Court Session Judge Kamrup, Guwahati, for commission of offense under 8C of NDPS Act 1980, punishable under section so that is regarding our case, my lord. And kindly the next page, my lord, 14, my lord. That before the detainee was involved in affair with the dated demand, the officer of outpost Nelly under PS Zagiron affected seizure to 1200 of ganja from the truck number so-and-so and intercepted 3 persons, namely one is that Sohod Ahmed Loskar, Ataur Rahman, and Abdul Haq Sodri. The recovery of ganja truck bearing register number so-and-so were seized under NDPS Act so-and-so. On 6/6, the Honorable Special Judge Judicial pronounced the judgment wherein Muhammad Sohid Ahmed Loskar, here the petitioner, my lord, and Ataur Rahman were found guilty under section 20C of NDPS Act and were convicted for the sentence under reasonable imprisonment for 10 years, my lord.
No other case.
Yes, my lord. And our order of, my lord, detention in page number 16, my lord, running page 116, my lord.
So he is undergoing sentence.
No, that has been undergo reason for 10 years, my lord.
He is undergoing sentence.
No, my lord, that has been completed.
That has been
Completed, lordship.
6/6/2003.
Yes, my lord.
So that 10 years period is already over.
Over, my lord. And our period is, my lord, that is in page number 116, my lord. Running page 116, my lord.
Yes.
Yeah, I mean in the last paragraph, my lord. Now, therefore, in exercise of the power conferred by Section 9F of the Prevention of Illicit Traffic, Narcotic Drugs and Psychotropic Substance Act 1980, the central government hereby confirmed the aforesaid detention order dated 28/12/2012, further directed under Section 11 of the said act that Sohanud Ahmed Loskar, son of so-and-so, be detained for a period of 1 year from the date of his detention, that is 18/1/23.
That period is already over.
Over, my lord.
Now under which case he is under detention?
My lord.
That period, the one is already over.
That is 18/1/20, 18/1/24.
17th of January 2020.
Over, my lord. Over.
Thereafter, why is under detention?
My lord. That is, my lord.
That is what we wanted to know from you.
Yes, ma'am.
Why the petitioner is under detention after 1 year of completion of this order?
Our period is up already over in 17/1, my lord. Now
Why he is under detention? That's what we want to know.
my lord.
Is it because you are?
Okay, ठीक है, sir.
Madam, that without even going into any other respects,
Yes, my lord. Only.
period is over,
Yes, my lord.
1 year period.
Yes, my lord.
And under the law, you cannot detain a person
Yes, ma'am. That is.
unless he is convicted or his detention is authorized or permitted under the law.
Yes, my lord. That is, my lord, fact, my lord, that my instruction is that their instruction is that detention period has already been over in 18/1, my
Then you
lord.
have to release him
Yes.
on the very next day. Because his conviction in the other case, that also came to an end, 10 years conviction, that was of 16th of January, I think, 2013.
Yes, my lord. Yes.
16th of January.
Yes.
So in 2023 itself, that conviction was over. And in the meantime, you passed on to the PIT.
Yes, sir.
That was for 1 year. That is also over in January 2024.
Yes, ma'am.
Now we're in February. We have been granting you time only to get the instructions. What is the grounds under what provision of law you are detaining him?
My lord, as per my instruction, my lord,
My lord, our period of detention was only for 1 year, my lord. That has already, but that is, they
But
don't.
that we know, that,
then-
that is not the instructions you are required to take.
Yes,
Your
sir.
instruction is, can you prevent a person after the detention period is over? And if so, under what provision?
At this stage, my lord, we are government.
Where are you, madam?
In Central Jail, Guwahati.
Central Jail, Guwahati.
Guwahati.
Because you are taking into principal file protection. Principal health already.
Yes, government council, who is there? You'll tell us tomorrow in which particular case the petitioner is under detention in the Central Jail, Guwahati, and why he has been kept in detention after since 18/01/2024, right?
Matter may fix on Thursday.
Tomorrow, what Thursday?
Lordship.
This is a preventive detention. You cannot detain a person, please tomorrow, without the authority of law. Even 1 day's detention is enabling both the respondents in the Union of India. In the Ministry of Finance, Department of Revenue. Put in bracket. Prevention of illicit traffic in narcotic drugs and psychotropic substances division, as well as the Joint Secretary Government of Assam, Home and Political Department, and the Superintendent of Central Jail, Guwahati, as to why the petitioner is under detention with effect from 18/01/2024 on completion of his detention of 1 year pursuant to the order dated 06/04/2023 issued under number U dash 11011/41/2022 PIT NDPS issued by the Ministry of Finance, Union of India, Department of Revenue, PIT NDPS Division.
মিটিঙত থাকি তারপর মোৰ পৰা চলছিল আছে।
My lord, for the same accused, another accused lordship, petition is pending lordship. It is in Friday's list lordship due to paucity of time lordship could not take up that matter.
That is a different
That,
issue. Tell us
that
more.
this may be taken up along with that lordship.
Not this, we'll have it.
That,
So
that, in that case also period over lordship. They
We are not on that.
said, that is WPC.
That case is similar or what?
Similar.
Same APIT, eight,
Yes,
same case.
same petitioner is different.
Same case.
Same case, out of same case, out of same lordship.
And the date of detention is.
Same, all are same.
Other petition.
Yes.
Other accused.
Other accused, for other accused. That is petition number 30.
Whether his period is also over.
Yes, lordship. Same lordship,
By which order he was maintained in detention?
same lordship.
Petitioner as well as the other accused.
Atto Rahman.
What is
Case
the
number Atto Rahman lordship. WP criminal number 38 lordship, 23.
List. On such and such, Friday.
Friday, it is on Friday, I think. You said that is, listed on Friday?
Uh,
The other one?
Okay, no, that is not, yeah, it was in Friday's list. Lordship could not take up on that day. That is why lordship,
Okay,
Uh,
last Friday.
last Friday. Can it be tomorrow along with this lordship?
Tomorrow getting the records may not be possible. This
List along with WBC number
38/2023.
38/20.
on Saturday?
On 17th.
Can it be Friday lordship?
On
Can-
Friday.
Obliged to me.
Itu Friday.
Oh, 8 to